In this video, we would like to discuss the relative impediments or prohibitions those were imposed under Islamic law regarding a nikah or a permanent marriage. As already we have discussed regarding absolute impediments or prohibitions which lay down under consanguinity, affinity, and fosterage, and any such marriage in violation of these absolute impediments or prohibitions would declare the marriage as null and void. But in case of relative impediments, any marriage in violation of relative impediments would be declared as irregular. So there are five such grounds which declared any such marriage as irregular under relative impediments or prohibitions. And there are five such relative impediments or prohibitions. One is unlawful conjugation, and the second one, the woman undergoing Iddat, and the third one, differences of religion, and the fourth one, marriage with a fifth, and the last one or the fifth one, marriage on pilgrimage. So, regarding the first one, unlawful conjugation, it exactly means the prohibition of unlawful conjugation lays down that a man may not have at the same time two wives who are so related to each other by consanguinity, affinity, or fosterage that if either had been a male, they could not have lawfully intermarried. Thus, a person cannot marry two sisters or an aunt and his niece. The Shias permits a marriage with wife's aunt, but one can marry one's wife's niece only with the wife's permission. The rule of unlawful conjugation applies only when the first marriage subsists. So, our second one would be whenever a woman is undergoing iddat. So, marriage with a woman undergoing iddat, the Muslim law lays down that when a marriage is dissolved by divorce or death, the woman must wait for some time before she can marry. The different period of iddat are provided depending upon the manner in which the marriage is dissolved. So, in case of divorce, either three menstruation courses or three lunar months, or till she delivers the child if she was pregnant, and in case of death of the husband, the limitation period is 4 lunar months and 10 days, or until delivery of the child if she was pregnant at the time of death. But if the marriage has not been consummated, she is not bound to observe any period of iddat and is free to remarry immediately. So, iddat exactly means the period of observing certain prescribed limits for a woman who is either divorced or whose husband has died. So only after observing that period of iddat, she could remarry again. So our next one is difference of religion, and this marriage is also is declared as irregular. So to make it regular, there could be a conversion of either the male or the female. So by that way it could be regular. And regarding marriage with a fifth one, it could also be regular, as because it was declared as irregular, it could be made regular by divorcing any one of the first four wives. So by that way the marriage could be regularized. And the last one, that was marriage during or on pilgrimage, and regarding that the Ithna Ashari and Safi Lodge, the Ithna Ashari Shias school and the Saffis Lodge laid down that a person who is on a pilgrimage should not marry. For example, a person enters the sacred place of the Kaaba in Mecca in pilgrim dress, finds another woman there and marries her, the marriage will not be valid. It is submitted that such a marriage cannot be declared null and void, but only irregular. So, these are the various provisions under Islamic law regarding absolute impediments and relative impediments are prohibitions, while absolute impediments, in violation of which, if one married, then such marriage would be declared as null and void. But in case of relative impediments, any marriage in violation of these five provisions would be declared as irregular, because these marriages under relative impediments could be rectified and it could be turned into a regular marriage. So, we have completed nikah, muta marriage, and the very prohibitions and impediments and the various grounds of a valid nikah or a permanent marriage under Islamic law.